Okay, Madam Chairman, it's 7 o'clock.
Good evening. I call to order this regular meeting of the Minnehaha County Planning Commission and will begin with a few introductory comments. As a courtesy to everyone here tonight, please make sure that all cell phones have been silenced. Please note that tonight's Planning Commission meeting will be rebroadcast via CityLink and posted on the www.minnehahacounty.gov site for viewing by the general public. Any final action taken on the conditional use permit applications tonight will take effect 5 working days following this meeting unless a written appeal of the Planning Commission's decision is filed in the Planning Office by Wednesday, December 3rd, 2025 at 5 p.m. In the event of an appeal, the decision will be referred to the County Commission for a hearing on Tuesday, December 16th, 2025 at or after 9 a.m. The affected parties will be notified of the meeting date, and meetings of the County Commission are held in this same room. First on the agenda is public input. Is there anyone who wishes to speak on an item that is not on the agenda? At this time, the Planning Commission will consider the consent agenda. Items on the consent agenda are perceived to be non-controversial and meet all the requirements of the codes and regulations. The consent agenda will be acted on in one motion with no public hearing on the items unless a member of the public, the commission, or staff requests the item be removed from the consent agenda. Next, I'll read each item on the consent agenda and ask if there are any issues or comments from the Planning Commission or the audience. If any member of the Planning Commission or the audience would like to be heard on the item, please raise your hand and the item will be moved to the regular agenda to allow you to address the Commission later in the meeting. Any items remaining on the consent agenda will be approved by the Planning Commission with the conditions recommended by staff. Item number 1 is the approval of the minutes of the October 27th, 2025 meeting. Item number 2 is conditional use permit 25-68 to allow a Class 1 major home occupation, that is a hair salon, on the property legally described as Tract 1A, Hanson's Addition, Southwest Quarter, Section 3, Township 102 North, Range 48 West. That is in Brandon Township. Petitioner is Casey Brown. Property owner is Brandon Hanson, located at 25662 481st Avenue. Is there anyone from the Commission, staff, or audience wish to be heard on this item? Item number 3 is conditional use permit 25-69 to exceed 2,400 square feet of accessory building space. They're requesting 3,810 square feet on the property legally described as Tract 37 of Lot 1A, Peterson's First Edition, South Half, Northwest Quarter, Section 3, Township 102 North, Range 49 West. That is in Mapleton Township. The petitioner is Nick Mimak. Property owner is Vadim Omashuk. If I pronounced that wrong, I'm sorry. Located at 25639 Sherdine Trail. Is anyone from the Commission, staff, or audience wish to be heard on this item? Commissioners?
Madam Chair, I'll make a motion to approve the consent agenda.
Second.
I have a motion and second to approve the consent agenda. Any further discussion? All those in favor?
Aye.
Opposed? Motion passes. If your item hasn't been approved, you're free to go. We'll move on to the regular agenda. Any old business?
No.
We'll move on to new business. We have Fletcher Lackock here from City Planning. Shape Sioux Falls 2050 Comprehensive Plan Update.
Good evening. I'm Fletcher Laycock, Senior Planner with City of Sioux Falls Planning and Development Services. I'm here to give you an update on our the city's comprehensive plan update called Shape Sioux Falls 2050. This is an informational item. We were here before you in February 24th, 2025, after our first phase of public engagement was done, and we're we're wrapping up our third phase of the process and wanted to bring it before you for your information. So to give you pretty much an outline of our public input process, what key themes we brought out or trends that we found through our public engagement process, and then a little bit into how the City of Sioux Falls and Minnehaha County work together with growth management and land use. So that's our Chapter 5 and Chapter 6. And the picture on the up there is when we kicked off our public engagement process, we had a coloring contest, and that's the one that won the coloring contest and was on our public input summary report, which was brought before you in February. So this was a three-phase process, phase one being the project kickoff, and then phase two, we had all our public engagement, and we're coming to the end of phase three, which is drafting the plan. Giving you an idea of some of the public engagement we have, we had an ETC community survey with 541 responses, and that's a statistically valid survey of what the people in Sioux Falls are looking for. The other part we had that was very interesting was pop-up events. We held 8 events hosted by city staff where we went to different venues such as the Farmers Market and the Levitt downtown and Riverfest, and went and took our planning process to the people to get their input. And those were very successful events, which we hope to continue to engage the public with. And then another way to get engaged was the online engagement website, where we've had over 6,000 unique visitors to help us with our process. Another part of the process was stakeholder interviews and focus group meetings. So we identified different stakeholders and focus groups to provide us a broad range of views. And those views include local government and planning. So we did talk to all the different municipalities and counties around us. And even Bonnie is on our advisory committee. But this gives you an idea of who we reached out to, the school districts and other associations and utilities that help us plan for the future. So talking about the advisory committee, we had 27 community members, and we're still getting our final draft. Hopefully our final draft will be sent out to our advisory committee members by the end of this evening. Still drafting through, but we plan to have another meeting on December 8th with our advisory committee where we can get some final comments on the draft and then have something together final by the end of December. And here are some members of our advisory committee that we wanted to recognize. So we had key themes that were identified through our public engagement process. We call them trends, and then under those trends we'll have recommendations. We have housing and neighborhoods, transportation and mobility, conservation and resiliency. So in our plan we address each of these different trends and then identify recommendations to accomplish, to affect those trends. So that is the meat on the bone of this is how do we address housing and neighborhoods, which was identified as a key trend that people thought we needed to address. So we worked through that. And in our last public engagement process, we actually got people to rank our different recommendations under those different themes to help us prioritize. So when we get the final document out, it'll include 11 chapters. The big ones that we haven't talked about much are the trends and recommendations, sub areas, neighborhoods, and implementation. We're really excited about sub areas. What that is going to do is take our divide our city up into 12 different growth areas, and then we're going to do a more in-depth look in those different areas. So that will include looking out into our growth areas in Minnehaha County and then Lincoln County. So we'll have further engagement in how we grow. What we wanted to focus on tonight, though, is some of the growth management and land use in chapters 5 and 6. Nothing much has changed in growth management. The city still looks at where we grow, where city utilities are going to be provided. We don't want premature urban development out in the rural areas, which will have a need for increased services, which becomes a burden on the county system. So we really recommend, we haven't changed much of our recommendations. We look at where we're going to grow, where city infrastructure is going to be, And then that's where we recommend commercial and more urban development happening. And so each year we adopt development area maps or tier maps, and that shows where city utilities such as water, sewer, drainage, and streets are going to be constructed by the city, and thus in the next 1 to 5 years with tier 1, the 6 to 15 years in tier 2, and 16 to 25 years in tier 3. Those are the areas where we expect to see growth. So this is very helpful map for developers so that they know where infrastructure is going to be and when. Chapter 6, land use. This is our future land use map. And some of the big changes that we see are, you'll notice those orange lines along future arterial streets. It's basically identifying where we didn't have before, it just showed yellow residential in all our growth areas. This one's identifying that along those arterial streets that are proposed that we should have more of a high density, whether it's townhomes or duplexes or apartments. Not that we're saying that's the only type of development, but that's the expectation where you would want to see higher density residential development. And then inside you'll see that it still remains low density residential. But this is, not a huge departure from what we've had in the past. It just kind of expands out because what we're looking at out at 2050 is potentially a population of increase of 150,000. And so we need to be able to plan for that scenario in the future. So with that, I'm available for any questions on our Shape Sioux Falls 2050 Comprehensive Plan update.
Any questions for him?
Madam Chair, could you go back to that last map? What did those letters and all that mean on those, like around there? What is, in those circles, what is
Those
that?
are
I
the
can't see.
different types of nodes that we have. So the big red ones are where the mall area is, downtown. On the northeast, it's Dolly Farms. So the plan would be that in order to get the type of development that we need on the west side, we have identified a regional node. So that kind of tells you how many acres of commercial, how many acres of multifamily would be needed in order to, when development happens there.
So are the small cities, the blue ones, or is that commercial areas then?
Yes, they're primarily at the intersections of arterials, and so you'll notice there the different lines are different colors. So we kind of had to adjust, do we expect to see a huge development at different nodes, and how would we plan for that in the future? So, because we do have land use, so in the plan we have ideas on how population is going to grow and then how much land we need in order to serve future population growth.
So what's the difference between a regional and a sub-regional?
It's the amount of acres of commercial and other land uses within that node. So the big red ones, those are your super centers where you're typically going to have a Walmart or a major or large big box stores. And then as you get to smaller ones, it's smaller lots, but not as heavily commercial as the big red ones. So, and
What's the one way on the west side? Is that on West 12? Or
yes,
so you're planning on a gigantic regional center there?
it's not that it's as far as we're looking out to the future. That's where we could see one being.
Where's that at? So is that past 2 Ellis Road or?
So this is looking out to 2050. So we're not saying that it's going to happen. We're saying if it needs to happen, that's where it should probably be located.
What intersection is that? That's my question.
It's 3 miles past the T Ellis Road.
Oh, is it Highway 17?
Yes.
Okay. Okay.
Okay. Anyone else?
So again, as we get to it, we'll update again in 5 years. So it's not like this is all set in stone. This is a document that helped guide us in our decision making. So
It's just one other question. I think I asked you guys this before. The joint jurisdiction, was that every 5 years? Is that how far out it gets extended again or reevaluated? Is that right or not?
I don't know that there's a time limit or time frame that we look at it, but
I was just wondering how far out do you go and how do you keep increasing going out in joint jurisdiction area?
that would be an agreement between the city and the county.
Okay.
For our growth boundaries and where we want to share joint jurisdiction.
I wasn't sure. I thought it was maybe 5 years or something. You reevaluate and go out another couple miles or something like that, or not. But it's
It
not.
was, I mean, I don't know if you saw in the news in the past couple of months, we did work with Lincoln County on adjusting our joint jurisdiction map with them. And it's kind of based around Lincoln County water service areas, our agreements with Harrisburg and T as far as where our growth boundaries are. So Highway 106 is on the south end. We finally agreed, like, yes, this is where Harrisburg's growth area and the city of Sioux Falls will divide. So it's been a great process for us to build those relationships with those communities. And I think we do need to probably look at it for Minnehaha County in the future. So
Okay. I'm just curious. I didn't know how far out you go or how often you adjust those boundaries, I guess. That's what I was just kind of wondering.
all right,
Thank you, Fletcher.
thank you.
The next item on new business is the annual review of open meeting laws. Maggie?
Good evening, Madam Chair, members of the Minnehaha County Planning Commission. My name is Maggie Gillespie. I'm a Deputy State's Attorney, and I'm here to provide you tonight with a brief overview of open meetings requirements in South Dakota. This past legislative session, a new law was adopted which requires political subdivisions to annually provide an explanation, of open meeting laws once per year. And so we're fulfilling that requirement here tonight on Thanksgiving Eve, and appreciate the opportunity to provide this compliance requirement for you, Madam Chair. Tonight we're using the Attorney General's materials because that's what statute requires, is that we're to use the Attorney General's materials in presenting this information to you. And those materials are composed of two items. The first item is the PowerPoint, which is before you, and the second item is a pamphlet, which is also published by the Attorney General's office, and you also have a copy of that. There is a copy, Kevin has a copy of that, but I see he's got the the PowerPoint queued up, so we'll just go right to that. This is just a briefing. It's not a question and answer session. We're not intending to provide any legal advice tonight by presenting this material from the Attorney General's office to you. So we'll start with the open meetings pamphlet, with the PowerPoint. And so that would be the one that has the slides and then a place for you to take notes on the side. So Kevin's right on cue here with the basic rule. And so as you can see, the basic rule under Title I, Chapter 25, Section 1, I'll just read it. All official meetings of any public body are open to the public unless a specific law is cited to close the meeting. So that's where you start with, what is a meeting? It needs to be an official meeting to trigger the open meeting requirements in South Dakota. So what's the purpose of an open meeting? The Attorney General provides us with a 41-year-old South Dakota Supreme Court case, quoting, to prohibit actions being taken at secret meetings where it is impossible for the interested public to become fully informed and to detect improper influences. Madam Chair, I would note that I did provide, just in case any member of the public wanted to see the materials that the board's been presented with, I did provide a copy of that up at the dais. An official meeting is defined as any meeting of a quorum of a public body at which official business or public policy of that public body is discussed or decided, whether in person or by means of teleconference or electronic means. And in addition to meeting together as a body like you're doing tonight, we'll also talk about teleconferences and electronic means. So in order for an official meeting to commence, you have to have a quorum, which all of you are well familiar with, I'm sure, that being 4 of the 7 of you in order to have a quorum. So then the next slide, please. In order for an official meeting to occur, it's a 2-part test. There needs to be a quorum and there needs to be a discussion or a decision on official business or public policy. So then if you would turn to your page 3, the next slide is titled Official Meeting. So a regular meeting is an official meeting, but the gray area becomes these items on the screen that you may attend, such as a lunch, a sporting event, a social event. We've also included email discussion. We'll get into specifics of that. But for these first 3 situations, these events like a luncheon or a sporting event or a social event, for those 3, it's not likely that at any of those events that you'd be discussing public policy or public business, nor should you be. Instead, generally, those would usually not be a meeting where an obligation exists to publish notice of such a meeting. So the next slide. The exception to that would be if it was a meeting of another public body, so we'll talk about that in a moment. So on this slide, we're going to get into details about email discussions. So with electronic messages, you do have to be careful, because as long as, you do have to be careful to not slide into having a public meeting by email. So, for example, if you received a group email and you responded to everyone in that group email with a substantive discussion about business, public policy, public business, that could be a meeting. So it depends upon what the substance of that response would be. And so with electronic messages, you really want to be careful in not responding in substance to an email where a quorum of your body is present, because that is essentially a meeting, depending on what your response is. The Attorney General's office has listed the different types of electronic means for us, because of course it's not just email anymore, is it? It's instant messaging, social media, text messages, virtual meeting platforms. It's important to note that the Attorney General reminds us that communications that are only for scheduling purposes are excluded. Okay, so next slide, please. On official meetings, there are exceptions for you to keep in mind. And those would be, number 1, it's listed here, meeting with other bodies. Okay, so you as a body are invited to attend the meeting of another government body. So they are required to comply with the notice. You don't have to. The next exception would be if you're attending a press conference that was called by a representative of the body. That's an exception to providing notice. The other important exception would be an event that was scheduled by a non-governmental entity. So this is slide number 10, page 4. Just so that you can keep up there. And here you can see that this type of attendance at a non-governmental entity meeting must be posted. There must be a notice of agenda posted. And all the requirements, the posting requirements, the time requirements, the place, the date, all under 125, our state chapter on open meetings, have to be complied here. And the key is because that non-governmental entity is not going to post the meeting because they're not subject to the open meetings law. And so that's why it's important to keep in mind if you attend a meeting like that, it needs to be posted. If you have a quorum attending the meeting, okay? So we'll skip the next section. That's on townships. We'll skip the task force. We'll go next to it's slide 13, page 5, entitled Public Notice. I'm just going to note here that for political subdivisions like the county, here are the requirements of a political subdivision. Notice of the meeting, including a proposed agenda. You must state the date, time, and locations of the meeting. And then the notice has to be visible to the public, readable. It has to be continuous, 24 hours immediately preceding the meeting, and it has to be posted at the principal business place of the public body. And if there's if the county has a website or the public body has a website, it also needs to be published there. And I'll just, give a plug to your county employees who are working for you. They all do a fantastic job. Director Scott Anderson and his entire staff do a great job in taking care of all of this for you. So the next slide, public notice again, slide 14, page 5. So this just touches on a special meeting or a rescheduled meeting. Same requirements all apply. The only special thing that I'll note is the media has to be notified if they've requested notice. So you either have to call them, email them, or present it in person. Or excuse me, mail, email, or in person. And by law, the county has to make an honest effort with that. We'll skip the next slide. That only involves state boards. So we're on page 6, slide 16. This is printed materials, and printed materials must be made available to the public if it's provided to the body, or it has to be posted on the website at least 24 hours before the meeting if it's provided to the body. If it hasn't been provided to the body or posted on the website, then a copy needs to be brought to the meeting in the meeting room, which is what we've done here tonight. The exception would be for exempt material. That would be materials that you are expected to be discussing in executive session that have been pre-prepared or attorney-client privileged information. The next slide, public comment must be allowed at all official meetings with limited exceptions, which I know you're well familiar with. We'll skip the next slide and go on to executive session. So the question becomes, especially for new board members that have never served before, unlike yourselves, when can you close a meeting? And when can you close a public meeting? And state law lays out specific specifications as to when a meeting can be closed. So those are all listed there in slide 19 for you. SDCL 125.2 provides that executive session, which is a closed session, unavailable to the public, may be held for discussion of public officers or employee competence or qualifications, student discipline, which you're never going to deal with. The third one is communications with your attorney, reviewing communications about proposed or pending litigation or contractual matters. So just basically legal matters. The next one, preparing for or conducting labor negotiations, marketing strategies of government-owned business, you'll never deal with that. And then the last one, information about the protection of public or private property and any person, that's really a security issue. There are some other exceptions that allow for a meeting to be closed that aren't listed here, that are provided in other places in statute. So there is, for municipalities, there's an economic development provision. There may be situations where you have to go into executive session because of confidential medical information or perhaps mental health information. And then there is an all-encompassing statute on which loops in federal and state constitutional provisions. Okay, so then just in terms of how you go into executive session, slide 21 there provides to you that there needs to be a motion, a second, and a majority vote. And before that motion is made, there needs to be a statement about what the purpose of the executive session will be. And so that the person that's making the motion is clear that they know why you're going into executive session. And perhaps the person making the motion simultaneously then announces the purpose of executive session. And then just a general rule that no action can be taken in executive session, and no matter can be discussed in executive session that wasn't included in the motion or allowed by state law. Okay, the next section is on teleconferences. So this became an issue during the pandemic. It wasn't possible to safely social distance. And so remote meetings became more common with the county. Not so much now, but we've lived through that, so we know how that works. And so what the law provides, the main key here is how the vote needs to be conducted. And the law's changed a little bit since it used to be that if there was a teleconference, the vote needed to be by roll call. But now that's been changed so that the only time there's a roll call required if there's someone appearing by teleconference is if there's a no vote. And then there needs to be a roll call taken so that the record is clear about the ayes and nays. And then, of course, boards have the option to require more stringent standards and say, we're going to take a roll call every time because maybe the chair wants to be clear about how the vote is. And then if there's not a quorum in the same room, then the public has to be given an opportunity to listen in on the meeting. So if a majority of members are appearing remotely, then the public needs to be able to call in so that they can hear everything that's taking place. There's some statutory requirements on meeting minutes, and again, our county does a great job for you on these requirements, but there are certain statutory requirements set forth there. That pretty much covers everything. The rest of the slides are really on the Open Meeting Commission, and just laying out that this is a required training that needs to appear in the minutes to prove that you complied with state law, this new state law that went into effect July 1st. So thank you, Madam Chair and members of the commission, for allowing me this opportunity to present this information to you tonight.
Thank you.
Thank you.
Any other new business? I'll entertain a motion to adjourn.
Second.
All those in favor?
Aye.
Opposed? Motion passes. Thank you, everyone. Happy holidays to all of you.
Thank you.